Property insurance companies have a duty to their customers to investigate all claims timely, fully, and in good faith. The failure to meet the duty of good faith during the claims handling process can leave insurers in a lot of trouble, as American Reliable Insurance Company and Global Indemnity Group, LLC, recently found out. Let's have a look. According to this article in SiliconValley.com, a jury in California awarded two sisters $18 million from an insurance company that offered only $5,000 for storm damage. The article reads, a San Bernardino County jury has awarded two women $18 million after determining their insurance carrier acted in bad faith when it failed to pay out more than $100,000 to cover repairs for their flood-damaged home. According to the lawsuit filed in San Bernardino's Superior Court, rainwater from a large storm in February of 2019 flooded the home, and the damage rendered their property uninhabitable. The two sisters, according to the lawsuit, gave their insurance company timely notice of the damage, and the insurance company had an inspection done at the property. But the claims adjuster, according to the lawsuit, underpaid the claim. Water and mud in the home's crawl space destroyed the heating and air conditioning system and damaged the electrical system, leaving much of the house without electricity. And cracks began appearing on the walls throughout the homes. And so they went and sued American Reliable Insurance Company and its parent company as a result of the undervaluing of the claim. And Global Indemnity paid out $5,000 on the claim, even though the plaintiffs had a contractor come out and provide an estimate that the repairs would cost over $100,000. According to the attorney, the siblings, the two sisters, were forced to live in their home without heat for about 5 years while they battled their insurance company in court. But in October 23, they ended up paying $140,000, which is the full amount of the policy, to the sisters. And they said that they were previously unaware that the sisters had been living without heat. So from the time that they had this storm in 2019 and then filed the lawsuit in 2020, up until October of 2023, according to the insurer, they didn't know that these people were living without heat, that the home was uninhabitable. That kind of defies belief. But the insurance company maintained that it was an oversight that their insurance adjuster had missed. Now, the jury, as we'll see, didn't buy this. So this is the jury verdict form. This is a special verdict form from this case. And on the breach of contract action, the jury answers yes to all the questions, which is unimportant until they get to question number 4, which is what is the amount of the covered loss that the defendants failed to pay to the plaintiffs? Now, if you remember, the insurance company ended up in October 23 of paying out the entire value of the policy. So when it comes to question number 4 on this verdict form, well, the defendants covered the entire loss up to the policy limits. So there was no amount to put into this breach of contract damages portion of the jury verdict form. Now, if we had just stopped at the breach of contract action, then the plaintiffs would have essentially proven that a breach of contract occurred, but other than the interest on that payment, they likely wouldn't have been awarded any damages. However, they also alleged a breach of the covenant of good faith and fair dealing. Now, that is the duty that I spoke about earlier, to investigate all claims in good faith. And there are some pretty poignant questions here. One of the questions is number 3, did defendants unreasonably or without proper cause fail to pay or delay in payment of the policy benefits? And the jury said yes. And did they fail to conduct a full, fair, prompt, and thorough investigation? Yes. Was defendants' failure to pay or delay of payment based on a genuine dispute as to the amount owed? So essentially, if the insurance company says, look, this claim is valued at $50,000 and the plaintiff says, well, no, this claim is valued at $65,000. Well, the two can go to a lawsuit and the insurer won't be dinged because their estimate of the claim came in lower than the plaintiff's estimate of the claim, and the plaintiff decided that they weren't going to accept the insurer's estimate. But when you have something as markedly different as $5,000 of an offer made by an insurance company and then $140,000 full payout on the policy during the pendency of the lawsuit, well, it's kind of hard to say that there was a genuine dispute as to the amount owed. But the most important question on here is question number 7. It says, did defendants act with malice, oppression, or fraud? And the jury answered yes. So we get to the bottom here, and the jury awarded $3 million to Jennifer Garnier and $3 million to Angela Toft for their physical pain, mental suffering, basically because they lost the use of their home, because they lived there for 4 years without heat. There was some anguish that was associated with that. And so the jury awarded damages for that to the tune of $6 million in total. But because they answered yes to this malice, oppression, or fraud question, well, then the jury got a second verdict form. So it's likely that the jury didn't know that they could award punitive damages in this case, but once they answered yes to that question number 7, well, then they got this punitive damages verdict form, which asks 2 questions. What amount of punitive damages do you award against American Reliable Insurance Company, to which the jury responded $2 million? And what amount of punitive damages do you award against their parent company, Global Indemnity Group LLC, to which the jury responded $10 million. That's a total of $12 million just in punitive damages that these insurers were required to pay. And that's in addition to the $6 million in damages to the plaintiffs for the loss of use of their home and the mental suffering and whatever other suffering they endured while they were going through that experience. And that's in addition to the $140,000 full policy limit payout, which is in addition to all of the attorney's fees that they have been expending between 2020, when this lawsuit was filed, all the way up to 2024, when the jury finally resolved this entire matter. So these insurance companies, essentially, for a smaller business, would have engaged in bet the farm litigation. But because these insurance companies are so large, $18 million is really a drop in the bucket. And that's where the punitive damages award comes in. It tells these insurance companies, look, if you engage in these types of practices, then you can face punitive damages, which, if you keep doing this, aren't going to end up being drops in the bucket anymore. It's going to fill up the entire pail. So these cases are very important, and I like to highlight them when we see them. If you have any questions about this or any comments, let me know in the comments below. For now, my name is Nathan Saunders, and this is The Legal Good.